explained it to who asked those questions. And the reasons are significant. I mean, putting aside the inherent conflict of the state of Michigan and its passing the MMFLA, the licensing for medical marijuana facilities, signing into law Prop 1, which allows the use of marijuana similar to alcohol. The idea that it remains a Schedule 1 is absurd. And all these laws that have been passed and made part of our legal system have displaced marijuana's placement as a controlled substance. That's our argument. And
It's a pretty good argument.
So,
And can I just say that Jeff's a little bit of a troublemaker.
International troublemaker, actually.
so
He really is.
I do want to look at this guy. So the rant starts with this guy, Kyle Kaminsky, who is from the Lansing City Pulse, who will say, we're a pretty progressive magazine, so not much to worry about. I joked with him beforehand, don't quote John Sinclair's swearing. He's like, oh, or at least don't make him sound like, and of course they got him in here swearing. He's like, oh, don't worry about it, we blah, blah, blah. And he went through this with me, and he does a pretty good job reflecting on the comments and the ridiculousnly of why it can't be scheduled and the reasons why. And then there's some confusion here, and this is really part of the rant, which is that, I say the continued placement on the Public Health Code defines marijuana as a narcotic or some type of dangerous substance completely contradicts the regulatory system that allows for medical marijuana. It's not a dangerous substance, it needs to be removed from the list immediately. They go on to quote me as saying, Comorn, however, couldn't offer a single example of an unlawful search and seizure since the passage of Proposal 1. Sinclair also recognized the lawsuit could be symbolic gesture, more of a symbolic gesture, than a mechanism of meaningful change. So I take issue with that, because when he asked me, is this just a symbolic gesture, and are there any raids? I said, well, maybe there aren't any raids, but there's still pending cases. How could we be treating marijuana and being punished and criminalized under the Public Health Code if it's still Schedule 1? I mean, this is still going on. So and there are raids that are taking place. But many police departments, I could tell you one that happened in Detroit, still taking place. But putting that aside, I want to get to the real problems that still exist with marijuana still being listed as Schedule 1. And I point to this incident, rather tragic. There's no winners in this. I argue this from a policy position and to make my case of why and the problems of marijuana still being Schedule 1. It's an unfortunate situation. This young girl, I think 21 years old, Blair Beck, 21 years old. No, I'm sorry. Blair Beck, 20, was killed in a crash by a 20-year-old driver, Logan Turner. She was convicted of the crime at trial, and she was sentenced 70 months in prison to 180 months, which is 6 years. And there's no prior record, and there was no evidence of a causation or correlation of the marijuana that was in her system that caused the accident. In fact, there was no observations of her being impaired. She had the blood results were apparently 5 nanograms of THC in her system. Now, the reason why a judge could potentially do this, and there's no question that this judge made an example of this young girl. She's 20 years old. She didn't get in a car drunk and drove, killed somebody. That's not what happened. She didn't use poor judge. And the idea that if she did have 5 nanograms, it tells you that it was not at a time that was immediately after she'd ingested it. It's a very common number if you look at the data as to a blood test for a patient or someone that uses marijuana recreationally. But it's certainly not a number that's ever been identified as a per se number with any study supporting it that causes impairment. Even the federal government studies. Now, I know Colorado has a 5 nanogram that makes it impaired driving, but that's just a law that they made. It doesn't mean that there's evidence to support it. But the point I want to make is that this woman was convicted of the crime of driving a vehicle with a Schedule 1 substance in her blood, causing death. It was not about marijuana. It was about that marijuana Schedule 1, the Schedule 1 categorization is what puts her in the category of being subject to, as if she was driving heroin, LSD, or what have you. And there being no requirement whatsoever of actual impairment. This is a conviction you have it in your blood, zero tolerance. It's Schedule 1. The vehicle that you're driving was involved in an accident that resulted in a death. That's it. Do you understand? It may not have been her fault, but the accident caused death. Could be nobody's fault. Do you understand? It falls. So when I say that there's potential significance on the value, and is this just a ceremonial or trophy lawsuit? No. As it remains in the Public Health Code as a Schedule 1, there are severe penalties associated with it. I mean, it doesn't even include the impact of it as dangerously defined for purposes of child protective services. I mean,
I think there's going to be some significant things come out of this lawsuit, is what I think. I think it's pretty profound, it's a pretty heavy thing to me to think that I was part of it and served it and everything, because I think it's going to be something big. Is my feelings. It's gonna set the tone for changes all the way up to a federal level, I believe. I think this thing is
really allows Dana Nessel to shine, because her interpretation of what the law is and how schedule is interpreted, I think, will really have a big difference in how it
The whole
gets
country
done.
is watching the state of Michigan.
And
Absolutely
then, by
true.
way of comparison on this, I had a case back when I was a detective. Girl about the same age, she was 19. Hit and run, hit a pedestrian crossing one of the main roads in Canton, and sent this pedestrian flying out of his shoes. One of those deaths. And pedestrian was drunk. We had good reason to believe the driver of the car was drunk. However, it was a hit and run. They split. I got called in, investigated at the scene, and while I was there and into the next morning, got a tip, went and found this girl, found the suspect hit and run driver. This girl was given, she ended up pleading guilty to, I think, 2-year misdemeanor negligent homicide, because it's too far beyond to determine alcohol level or impairment due to the hit and run, but she still had the leaving the scene of an accident causing death.
Yeah.
Pled to a 2-year neg hom.
Probation.
No, she did 9 months in the county jail. Was sentenced to 9 months in the county jail and some probation on top of that, I believe. So, not too far of a different case. I mean, but you're dealing with
County
alcohol,
jail,
hit and run, leaving the scene.
First of all,
accident
a
causing
sentence-
death, and then this girl, is
A sentence to the county
way
jail
an example.
versus being sent to 6 years in prison.
Yes, yep,
The difference of
It's
those
huge.
two existences,
huge.
I mean, can't be. And I'm not, listen, I do not want to come off as being unsympathetic to the terrible death that happened. I mean,
Exactly,
but as
exactly. But if you compare this, I see that as a similar.
If the
case.
judge is going to make an example out of it, there should be more support for
Yes.
cannabis being at fault or included in the issue before doing that.
And saying you're making an example absolutely says it's a prejudicial punishment that's being laid out.
Well,
Dictated not necessarily by the circumstance, but by the judge's own desire to make a public statement. And I think that's unfair
But
justice.
circle back around, and what Michael was saying, it's all about it being a Schedule I controlled substance.
Michael, you want to get a word in edgewise here, man?
So
No,
this
you're right.
lawsuit has the ability to change all that right here out of out of this little office.
Well,
Sycamore
let's
Law.
talk about some of the other things that I think are
Jeff
really
Fraser
problematic
causing trouble.
with this case and the driving issue, because I think that this is a topic that we will be talking about in the next coming weeks, because I understand that the pilot program has officially come to a conclusion, and that there will be recommendations made from a committee or gathering of a group of some kind that will
cannot
submit
wait.
that to the
I'm sure science will be
legislature.
considered.
Yes, science
Which I would say
will power the decision.
would suggest that a conviction for any presence should be questionable when the legislature is doing an open investigation to determine what levels are culpable for criminal behavior.
Of course
They
it
don't
should.
know.
But she
Maybe they
gets
don't know.
sentenced to 6 years in prison
Right.
when tomorrow or next week they're going to come up with a recommendation and it could be 6 nanograms.
Well, the judge hates
Right.
marijuana. I mean,
I'm just saying, can I just point out that these two things are existing in the same world
Yes.
right now?
Yep.
We have a zero tolerance law. This girl was convicted of, treated like it's a Schedule 1, which it shouldn't be. And we're investigating whether or not, or if a number should exist at all.
right.
How's that bullshit gonna work when everybody's body's not the same?
Well,
No,
that's
that's
even
the
besides the point, right?
That is definitely
answer-
The
the
answer
answer-
is there is no number.
The answer is that there is no number, as Jamie points out, that
Right.
we've been down this path before.
They're going to give you
Michael.
a number.
I just want to say that I didn't smoke cannabis for 3 months and was still tested for 5 nanograms
Oh,
or,
man, Max.
or carboxy.
THC.
Well, you're a unique person, let's just be honest.
Yes.
Most of us have blood in our veins.
Dab
and
Master
you have
Max.
THC.
Oh, my.
I'm just saying that's
Oh, my.
He could have been smoking his hair.
Yeah.
That works like it stays in your hair. It kind of got
Yeah.
recycled.
I'm just
through there.
saying, like, put me in this situation. Me still testing positive, 5 nanograms, not consuming cannabis for 3 months.
Oh, you're going to jail, dude.
I mean, it's. Well, listen. For that purpose, a patient's card is the only salvation. Right. And
Yeah.
that's, I think, one of the things on
That's on the list.
agenda list.
But that's
if there was
that's short-lived, and we all know it. Because you guys are going to sue the shit out of somebody. Or something's going to get appealed, and they're going to have to find in our favor. It is.
What do you mean? Somebody's going to who's going to sue?
We're
about
not
what?
supposed to be subject to penalty for any use if you're over 21. That's the whole point. And this
You're talking legalization, not medical.
right?
I understand. Okay.
And I think that someone's going
Well-
to go to jail for it, and they're going to say the obvious thing, which is, I wasn't
Well,
intoxicated.
Her case could and should be that.
That's
right?
what I'm saying.
In fact, her case was charged with the law being as it is, and then Prop 1 came out, I think, while the case was going on,
Right.
like in that November period,
I mean,
and actually changed. So,
it clearly defeats
mean,
the purpose. But they will set a limit. That's the other side of that coin.
will they set a limit? Let's vote on it right now.
They will set a
Who thinks there's not what? Let's say
The
what we think they should do, and what
What they should do is
they
have
should
to
do, and what you
prove-
think they're going to do.
what
That's
they-
it. Jim,
what-
why don't
yeah.
you go first?
What they should do is have to prove there was A, bad driving, and then B, that there was some level of THC in your bloodstream that significantly impaired your ability to operate a vehicle in a safe manner. And not, oh, well, you were over 5 nanograms. Because at the end of the day, if there's no bad driving, then you're not under the influence.
Right.
And the law speaks to not restricting the police from arresting you and you being charged for driving under the influence. And I believe it was worded that way for a very specific reason, and this is it. It's not meant to say there should be some arbitrary limit that means nothing. Now, if they can back it up with science, then let's have a discussion about it. But what is scary is that these politicians that we have been backing, and there's a whole ton of them, are all talking about this and are all talking really kindly about a per se limit and believe there should be one. And that should be scary.
Listen, here's a question. What do you think they should do? You kind of answered it. And what do you think they are going to do? Answer both or one of them again.
So first,